Good morning, ladies and gentlemen. I want to welcome you to the Superior Court of Gwinnett County's Family Violence Division. The cases on this calendar all involve petitions for restraining orders filed pursuant to the Family Violence Act. The status of your case is that a temporary protective order was issued on an emergency basis in what is referred to as an ex parte hearing. At that hearing, the judge heard only sworn testimony from the petitioner, and based on that testimony, determined that there was enough of an emergency to grant the protective order on a very temporary basis. Today, the court will hear from both the petitioner and the respondent before deciding whether or not to continue the protective order for a period of 6 months up to 1 year. For your information, Georgia law provides for two kinds of protective orders: those issued pursuant to the Family Violence Act and those issued pursuant to the stalking portion of the Family Violence Act. For the Family Violence Act to apply, the parties must have a qualifying relationship. Qualifying relationships include current and former spouses, persons living or formerly living in the same household, parents and children, and parents of a common child or children. If you do not have a qualifying relationship, you can only seek relief pursuant to the stalking portion of the Family Violence Act. Each has different legal elements, which I will discuss. In order to obtain a protective order under the Family Violence Act, the petitioner must first demonstrate that there has been an act of family violence. Under Georgia law, an act of family violence is defined as any felony offense or certain misdemeanors, including assault, simple assault, battery and simple battery, criminal trespass, harassing telephone calls, unlawful restraint, or stalking. In addition to establishing an act of family violence has occurred, the petitioner must also prove that there is a reasonable likelihood that acts of family violence will continue to occur in the future. Although verbal abuse can indicate a serious problem, mere verbal abuse is not legally sufficient to form the basis for a protective order. The statute is intended to keep you physically safe. Therefore, any evidence or testimony to establish that you are in physical danger is material to a family violence case. At the trial, the petitioner has the burden of proving that one of the qualifying crimes has taken place and that there is a reasonable likelihood of similar future activity. In order to obtain a protective order under the stalking portion of the Family Violence Act, the petitioner must establish that the respondent has engaged in a pattern of conduct that is solely for the purpose of harassment or intimidation. The key word is pattern. In other words, the petitioner must prove that the respondent has attempted to contact, followed, or placed the petitioner under surveillance on more than one occasion, and that he or she did so as a means of harassment or intimidation. If the court finds that the conduct at issue does not rise to the level of stalking, the petitioner can request that the court give the respondent a harassing telephone calls and/or criminal trespass warning. In that event, the court would formally warn the respondent not to call the petitioner and/or go to his or her place of residence. The respondent would acknowledge receipt of this warning in writing. Thereafter, should the respondent violate the terms of the warning, the petitioner would have the opportunity to apply for an arrest warrant in the Magistrate Court of Gwinnett County, either for harassing telephone calls or criminal trespass. Information on warrant application procedures is located in the clerk's office. Please keep in mind the legal elements of family violence or stalking as I now explain the 3 ways your case can move forward today. At the call of the calendar, the court will ask you how you want to proceed. These are your options. Most cases proceed to trial. The petitioner has the burden of proof at trial. The court will call the case and ask the parties if they are ready to proceed. The court will hear from the petitioner first and the respondent second. If there are multiple protective orders involved, the court generally hears from the petitioners in the order the protective orders were filed. Please try not to interrupt or disrupt the other party's testimony or case presentation. I can assure you that the court will not make any decisions on whether or not a protective order is appropriate until after hearing all testimony and considering all evidence from both sides. In the event the court decides to grant the protective order, the trial will proceed into a second phase where the court will consider issues of child custody and placement, child support, visitation, who gets to live in the residence you may have shared, and any other issues related to dividing up any personal property such as cars and furniture. If you have jointly incurred obligations to pay debts, the court may also consider a payment schedule on those debts. Insurance coverage, counseling options, and any other issue that you may have in your individual case will also be considered and ruled upon in this second trial phase. If you are seeking child support, you must complete the required child support worksheets. If you have not yet done so, at the call of the calendar, please let the judge know you need the required forms to fill out before your trial. A second way that the case can be resolved today is by voluntary dismissal. If you are the petitioner and no longer want to pursue a protective order, please make that announcement when the judge calls your case. The court will prepare a written order of voluntary dismissal for you to sign. The court may also ask you some questions about whether your choice is voluntary, whether anyone has pressured you to dismiss the protective order, and whether you have had the opportunity to speak with a victim advocate, if so desired. Since this is a civil proceeding, the petitioner always has the right to voluntarily dismiss the case. However, a voluntary dismissal does not act as a procedural bar to refiling another protective order if necessary. The final way to resolve a protective order is by consent. If you are the respondent and do not oppose the protective order, you can consent to its entry. In the event of a consent or settlement, the court will enter the protective order upon the terms agreed to by the parties. In a consent agreement, the court does not make any factual or legal determination that an act of family violence has been committed. This means that you will not have a trial. The court will ask you at the call of the calendar if there is any possibility of a consent agreement in your case. If both parties in your case would like a chance to talk before trial to see whether there is any possibility of entering into a consent agreement as to some or all of the issues that will be decided today, the court can provide you with the time and a safe place to do so. The parties can consent to some of the issues and leave the remaining issues to the court to decide at trial. No one is required to engage in settlement discussions. There are allegations of violence in these cases, and if you are not comfortable talking to the other side, you are not required to do so. Everyone's safety is our primary concern. The court often has a representative from the Partnership Against Domestic Violence present to facilitate settlement discussions and provide the petitioner with safety planning information and/or victim support. Please understand that this representative is neither an attorney nor an employee of the court. Finally, if an order is issued today and problems arise with that order, either as to the terms of the order or the failure of the other side to comply with the order, the court can only address these problems through the filing of a motion. Either side can file a motion to modify the protective order or a motion for contempt, which the court will set down for a hearing. The court cannot consider any issues related to an active protective order without the other party having notice and an opportunity to be heard on such issues. Further, if you obtain a protective order and want to make it permanent, you must file a motion to extend the protective order before it expires. There will be a court reporter present here today who can prepare a record of your trial at a cost to you. You will be informed of the rates for such service prior to trial. The takedown fee is charged at an hourly or pro rata rate. If both sides agree to have a record made, the court reporter will split the fee between the parties. You can only order a copy of the transcript if you participate in the takedown fee. The court will expect you to pay the court reporter today. There is an ATM machine downstairs for your convenience. The court reporter charges a separate fee for transcription of the trial. The transcription fee is charged at a per-page rate, also available from the court reporter. Some of you may have criminal charges associated with incidents that form the basis for the protective order. If you have criminal charges pending, please understand that this is a civil proceeding and not the trial of your case. Any testimony you choose to give will be taken under oath. Therefore, such testimony can and likely will be used against you at any future hearing or trial on your criminal charges. If you are facing criminal charges and choose not to testify today, the court will not consider your silence as any evidence of guilt on your part. However, the court can only decide the case based on the evidence and testimony received. Thank you for your attention. In a few moments, the judge will come in and call the calendar. When your case is called, please stand and inform the court how you wish to proceed.